The Supreme Court judge nominee, Justice Agnes Mercy Abla-Doji, has defended the current legal regime where there is no cap on the number of justices at the highest court of the land. The Constitution gives a minimum of 9 justices at the Supreme Court with no maximum. There have been criticisms of the status quo, with claims that incumbent government always abuse the system by rewarding justices who give judgments in their favor and appointment to the highest court. Justice Doji made this known when she took her turn before the committee that's vetting her. But now let's go to the committee and hear from President of the Ghana Bar Association, Nene Amegatcher, as he takes his turn before the committee.
Person, it comes to a state where your peers identify some qualities in you and they advise you that it is time for you also to render national service to the country. And it is upon that basis that I have to accept to give away all the perks and flexibility and all. I remember my wife asking me the implications of the appointment and whether we'll be traveling again to various places. I told her no more. She said, if that is the case, then the thing is not good. I said, well, you cannot have it all. Sometimes you have to make sacrifices here and there. So I'm here to make sacrifice for our mother, Ghana.
Mr. Chairman, I'm fine. In 1999, in Dakar, Senegal, and Papua New Guinea, then in 2011, I think in Cape Coast, you presented a paper on ADR. And in one of your responses to the question of the minority leader, you alluded to the fact that the bench is sometimes loaded with cases. And with these advocacy that you've been doing in your practice and all that, why are we not strengthening and applying the ADR system to make sure we lessen the pressure on the bench? What do you think we can do?
Well, where we have ADR institutionalized in the justice delivery system now, and we have an Alternative Dispute Resolution Act of 2010, Act 798, which regulates ADR in this country. So far, apart from the commercial court, where ADR is mandatory, in effect, it is a prerequisite for any judge to hear and determine a matter. In all the other courts, it is a question of a judge appealing to the lawyers and the parties to think about ADR and to resort to ADR. My recommendation would be that we should now extend the compulsory ADR mechanism from the commercial court to all other courts, so that between the time pleadings closes and the hearing date is fixed. In any case, between the time pleading closes and hearing dates are fixed, sometimes you have a gap of about 6 months to a year. That time could be used profitably to attempt the settlement of disputes. As a practicing lawyer, I can assure you that over 90% of the disputes which are in court could be resolved by alternative dispute resolution. It's happened in many countries in such a way that they've been able to decongest their courts, leaving the most difficult cases for the judges to try. So that's one approach. If we introduce the compulsory ADR, I believe, and then educating the litigants as well as the lawyers. Some lawyers believe that if they resort to ADR, they will not get their fees. But it is not true. The research that we have from other jurisdictions and which we have done is that litigants who are in pain are like patients. Litigants who have cases in court are like patients who are in pain. What they want is that they want relief from that kind of pain as quickly and inexpensively as possible. And therefore, if you're a lawyer and I approach you and within 3 months you are able to resolve my dispute and I have my peace, whether you did it by ADR or not, you are the person I will recommend to the next person. And it is better for you to charge, if you're going to charge 50,000 and stay in court for 10 years, than charging 20 or 30,000 and resolve a matter in 3 months. You are better off.
Final question.
Hold on. Honorable Amegatcher wants to follow up on that one.
You talked about the compulsory nature of arbitration at the level of the commercial courts. Is it by statute or it is the parties? Because you were making a similar recommendation for all other cases. Is it a duty for Parliament to compel, or currently the law provides that in the commercial courts this should be attempted, the arbitration should be attempted?
In the commercial court, Order 58 of the High Court Civil Procedure Rules makes that provision. So that is a subsidiary legislation. But under the parent legislation, the Alternative Dispute Resolution Act, the section says that the judge may recommend to the parties any judge who has a case assigned to, and the judge is of the opinion that the resolution of that case by ADR will assist the parties, could, with the consent of the parties. So that one with the consent of the parties. So where the party says no, then you are crippled as a judge. So it will need some kind of legislative reform, and I believe the Rules of Court Committee, should do that.
Yes. Mr. Chairman, my last question has to do with chieftaincy. And both of us are from the Gadangwe background. You agree with me that part of Greater Accra has not been stable when it comes to chieftaincy. Adan is stable, Ningo is stable, Prampram, Boom, Tema, La. But the worst of all is part of Gamashi. I want to know whether it's about selection, nomination, or succession planning that is really destroying this rich culture of the Gadangwe people. What do you want to advise us as a lawyer? What do you think they can do that they are not doing, which is contributing to this?
Honorable Nekwate, my senior colleague here has not presented himself as an expert on chieftaincy. And I discourage you from taking him into that area. If you formulate your question which he can answer, I'll allow it. But this time, you're moving into specific areas which are dangerous. And I please...
Then, Mr. Chairman, on this call, I have nothing to say than to wish my senior well.
Thank you very much. Honorable Ayaga.
Thank you very much, Chairman. Let me also join colleagues to congratulate the nominee and to also confess that I was a student and we definitely wish him well in this regard. My colleague asked you a question based on a paper that you presented. Who is responsible for the enforcement of the rule of law? you explained and you sort of said everybody. In that paper, did you consider the challenges faced in defining law in a plural legal system such as ours?
Thank you, Chair. I started that paper by reviewing the respective roles of various stakeholders within the Ghanaian system. The role of the executive, the role of the legislature, the role of the judiciary, the role of civil society groups like the Ghana Bar Association and other civil society groups. And my research led me to the conclusion that each one of them, each of these groups within the country have roles to play in ensuring and protecting the rule of law. And therefore, if Parliament will sit down for the executive to do anything at all, and they don't come out to put the executive on its toes, we will have rule of law infractions in this country. And if after having rule of law infractions, no one took up the matter to the judiciary for it to be determined, then we'll be perpetuating these infractions. So after reviewing all the role of the various stakeholders, my conclusion was that each of them had roles to play, and they ought to be called upon to play their roles effectively if this country will have to progress in its democratic dispensation, and if rule of law will have to thrive in this country.
Let me explain myself. The history of legal institutions and many other institutions here is one in which we had foreign European-styled institutions being superimposed upon existing indigenous institutions. So you see that also in the area of law and the administration of justice, that there were traditional institutions, customary laws, and a system of rule of law. And then a European one was brought and is being superimposed on that one. And so we have a plural system that are running parallel one another. And so my question is, in your effort to understand the challenge of enforcing the rule of law, did that fact of two parallel systems working feature in your analysis? Because if you even take all the discussions around alternative dispute resolution, alternative dispute resolution is not a new invention. As we speak, beyond the court systems and ADR in the courts, people on a daily basis in large numbers have alternative mechanisms for resolving their dispute using traditional institutions. So that's the question that I'm really asking.
Yeah, thank you. I delivered that paper in Papua New Guinea in 1999 about the traditional dispute resolution mechanism of African communities, where our heads of families and community leaders sat as arbitrators at that time and resolved disputes peacefully. And the impact of the European, the British rule and the imposition of a new system of dispute resolution. No, I reviewed all that in 1999. But in the paper that I delivered in 2015, I just took the prevailing law because what pertained before independence and even post-independence had been overtaken by the 1992 Constitution. So I was focusing more on the provisions of the 1992 Constitution, as well as the various interpretations. It looks as if various countries within Africa and other places have their own definitions as to what constitutes the rule of law. So I reviewed some of these definitions and then came to the conclusion that we as a community or a continent must know where we want to go. If we want to practice the rule of law that all persons are equal before the law, then we must do exactly that, rather than making some people higher or above the law and others who are subservient to the law. So that was the analysis which I did, having regard to the prevailing law of the country.
The second question, you've been advocating for many years, and you mentioned that you've done so at the Supreme Court. So since 1980, when you were called to the bar, I believe, and you've been observing the Supreme Court and the justices of the Supreme Court. Who would you say is your favorite justice, and why would that person be your favorite justice? What values did the person bring, or what qualities did the person bring to his or her job that would make you admire?
Are you asking him to choose between the judges of modern times, or?
No. Past, present, but not future, but past, present. Might not just be here, but even in England and other places. And what qualities about those judges, you know?
I'd rather you answer it this way. Is there any particular judge that has influenced your thinking? So there's no competition as to who is the best and so on.
I will say Chief Justice Fred Apalu of blessed memory, and Justice Francois, also of blessed memory, and in England, Lord Denning. I would say they have influenced my thoughts by the judgments which they delivered.
So I haven't finished. This is my second question. Chairman, the third one. I mean, that gives me an indication when I'm appearing before you, which rulings I should I should marshal. Well, you have led the bar. You've been involved in legal training. You've practiced, and so you have an appreciation of the market. There's, as we speak, some crisis in terms of legal training, the institutions, the numbers that want to be called to the bar, and there is some frustration out there. No, I'm not talking about the legal aspects, please. Let me finish. Yes, there's some frustration out there among young people who want to be called to the bar. As somebody who has been part of the system, leading the bar, being in the school training, young, advocates, and being a member of the profession, in your view, what should be the architecture, the design going forward to address the issues of the market, the quality, and at the same time, opportunity for younger ones to join the profession?
Thank you, Chair. The problem started when the National Accreditation Board started accrediting private law faculties to admit students to read law without reference to the General Legal Council. At that time, no market survey had been done as to whether the country was in a position to absorb so many lawyers, and whether even after those people had come out, whether there will be job opportunities for them. Secondly, we had rules in the Legal Profession Act which says before you are even qualified or handed your license to practice, you must have done your pupillage in an established chambers. We had not gone round to find out whether there are chambers which will be able to absorb all these numbers before accreditation was given to them. You look at the facilities at the Ghana School of Law. Those facilities were built by the first president, Osajifo Dr. Kwame Nkrumah, as far back as 1958. Since then, not even one office space had been added to the facility over there, apart from 3 40-foot containers that when you go to the law school, you see which are being used as offices. So we had this problem right from the word go, and we did not look at addressing these problems, and then we accredited private institutions, produce lawyers. And these people also, at the end of their 3 years, all of them said they want to come to the law school. Law school had not trained lecturers who could lecture all this number of people in the first place. They did not have the space even to absorb these students. So I found myself, for instance, having 250 students for an advocacy class, a practical class where I'm supposed to ask the students to practice examination in chief, cross-examination, and re-examination. And you have 250 students. How are you going to manage it within the period at your disposal? Impossible. So it was a crisis that has been created. And I think we ought to have a real look at the whole system right from the top. Right from we must go back to legal education and really look at everything, and then structure, because I believe that the General Legal Council must accredit institutions whose students it will accept to the law school to read law. In the long run, I believe that what will happen is that the Ghana Law School will be turned into an examination body where students, like it happens in America, they could go and do their course or training somewhere and then come and write the bar exams. But that is not what the Legal Profession Act says now, until it is amended and we get there. But where we are right now, my thinking is that the General Legal Council must accredit institutions. They must go in, inspect all these private institutions. Some of them do not have libraries. You do not know the lecturers who are lecturing in some of these institutions do not have the qualification. And I was shocked when I went to the lecture hall one time, and most of the students, all they had was photocopies of past examination questions and answers, and that was all that they were studying. You want to become a lawyer, and all that you are studying is questions and answers. I told them, I'm not here to teach you to pass an examination. I'm here to make you a lawyer. And they were shocked. They said, what's the meaning of that? I said, no, you are not here to pass examination. I'm here to train you to be a lawyer. When you have received that training, then all other things will fall in place. You automatically pass your exams. So we need a comprehensive overhaul of legal education in this country.
Yes, I have a lot to say on that, but I'll give other opportunities before. Yes, Honorable Wiamwa.
Yes, sir. Thank you, Chairman. Congrats, Nene. I have to put it on record that he's my good friend. Indeed, from his CV, I've also noticed that he went to a Blue Boys boarding, maybe 10 or 12 years earlier than me. I'm also a Manfo boy. And we share other things in common, which I will not state here. But that's why I've disclosed. I want to start with subsidiary legislation. If you look at Article 11.7 of our Constitution, it talks about Article 11.7, any other rule or regulation made by a person or authority under the power conferred by this Constitution or any other law shall be laid before Parliament, be published in the Gazette on the day it is laid before Parliament, and come into force at the expiration of 21 certain days after being so laid. Now, the Supreme Court in several cases has ruled that when such instruments are laid before Parliament, Parliament cannot exercise the normal legislative duties of considering such instruments, making amendments, and passing the instruments. The simple refrain is, if you don't agree, return to sender. What is your opinion on this constitutional provision where Parliament more or less has no opportunity to be able to amend what has been submitted or laid before it, but will only have to agree to what has been laid or return it to the so-called maker?
Thank you, Chair. The clarification I want is whether you want me to overrule the decisions of the Supreme Court. Because you have said that the Supreme Court had ruled on this matter already, and by our convention, once they've ruled, it is binding on all of us. So
not at all. Not at all. Not really. Indeed, there's been suggestions, including even at the Constitution Review Commission level, that such provisions should be amended for Parliament to have a major role when it comes to considering subsidiary legislation. So that's where I'm coming from, not that we should criticize what has already been ruled upon.
Thank you, Chair. My understanding of subsidiary legislation is that power has been given to a body to make legislation. And once Parliament, in its wisdom, decided to vest power in a minister or in some other body to make legislation, I do not think that Parliament should come back and have something to do with it. Otherwise, it will be duplication. If Parliament wants to do that work, it should do it. But once you think that this is something that a body with expertise should do it, and they have done it, then the matter should be closed. But that is why there's a provision, a proviso there, that if at the end of the day you were
Those are live visuals coming to you from Parliament, where the Appointments Committee has been sitting. You've just been hearing from Supreme Court Judge Nominee Nene Amegatcher there, speaking about the legal framework in this country. Basically, he talks about ADR and the fact that it has to be made compulsory for commercial and moved from commercial courts to all other courts. He actually speaks about the necessity for legislative reforms. And then he goes on to talk about legal education, which is what they were on. The last question came from Obi Amwa there.